Hi everybody, trademark attorney Josh Gerben, and today I want to talk about who is the proper person to sign your trademark application. So finding the proper person to sign a trademark application is actually a lot more complicated than it seems. It's in fact something that attorneys get wrong all the time. So today I want to go through two scenarios of how to select a proper signatory for your application, and then we'll talk about why attorneys get it wrong all the time. So the two scenarios I want to go through is one, if you're filing as a corporation or an LLC, and two, if you're filing as an individual without, just in your name personally. So if you're filing a trademark application under the name of a corporation or an LLC, the signatory, or the person signing the application, must meet two requirements. First, the person must be a corporate officer with authority to bind the company or the LLC. This means that you normally need a president of a corporation or a managing member of an LLC. Now there can be people down the chain from this, but you have to ensure that they're an actual corporate officer. So one of the things we see people get wrong is they'll say, Joe is the marketing director and he can sign the application. But he's not a corporate officer. It doesn't have legal authority to bind the company. So if he signs the application, the resulting registration can be completely void. So I know it's a hassle to ask your president or the managing member or the top dog in your company to come in and have to sign something. But ensuring that the proper person signing the application is critical to the rights you're creating. Now the second thing here is that the person signing has to have actual knowledge of the facts around the trademark. And what this means is that in the trademark application, there's a sworn statement that's being submitted that the person signing knows that the company has an intent to sell goods or services using the trademark or already has those sales of goods and services in the marketplace. In larger companies, it's entirely possible that some corporate officers don't have knowledge about this. They may not be involved in that particular program or for that particular product or service. So you have to ensure the person signing can in fact submit the proper sworn statement, and when they're signing that sworn statement, they could back it up if they're ever deposed in a court case later on. So now things get a little easier if you're just filing the application under your name personally. You just have to make sure you're the one signing. Don't let somebody else sign on your behalf. You could give somebody a power of attorney to do so, but it's messy and it's not a great idea. So just make sure if you're filing a trademark application in your name personally, you don't have a spouse sign it, you don't have a child sign it, you sign it personally. And this leads us to the point where a lot of attorneys get the person who's signing the trademark application wrong, mainly because the attorney filing the application signs it him or herself. It is a huge mistake to let your attorney sign a trademark application, and here is why. When an attorney signs your application, they are submitting a sworn statement that they have knowledge about the facts around the trademark, meaning they know your company's intent to sell goods and services, or they know about the actual sales that have already occurred. So if there's ever a challenge to your trademark application or registration, the attorney that signed the application becomes a fact witness and may be conflicted out from representing you. Not only that, but when an attorney signs the application, they need to have an actual power of attorney from you to do so, and many times when attorneys do sign applications, they don't have that requisite power of attorney on file. So as you can see, having your attorney sign the application, not a great idea, and making sure you're thinking about who you're asking to sign the application is critical to ensuring the rights in your trademark are locked in and not challengeable in the future. So I hope you found this video educational and enlightening, and if you have any further questions, please feel free to give us a call.